witness's refusal to give oral evidence at the inquiry, and in the latter category fall the affidavits of Mr. Mdluli and Greyling and Mr. Angelo Agrisi. The affidavits of both these witnesses make damning allegations against Ms. Giba. Neither witness was, however, willing to give oral testimony and to be subjected to cross-examination as contemplated by Rule 3.4. Ms. Giba did deal with the material allegations made by each of these witnesses in oral testimony, and we submit that those were not challenged under cross-examination and therefore stands. The affidavits of Ms. Nkasana and Mr. Agrisi can, in those circumstances, carry no weight and can in fact be disregarded by the inquiry. This is especially so in the light of Advocate Giba's own evidence presented to the inquiry. We then go on to deal with the individual witnesses, starting with Advocate Ferreira on page 35, and that runs through the bulk of her heads to page 63. And if I may just read from our conclusions, we have sought to highlight above the evidence which contained the most serious of the allegations against Advocate Giba, and to demonstrate that at its high water mark there is insufficient evidence for the inquiry to conclude that Advocate Giba is no longer fit and proper to occupy the office of the Deputy National Director with regard to her honesty, integrity, and conscientiousness. The institution of this inquiry, as I mentioned at the outset, was fueled by the ongoing narrative in the public domain that one of the senior leaders of the NPA was not fit and proper to hold office as a result of allegations of misconduct against her arising out of certain judicial criticism, and that this narrative and the allegations accompanying it are damaging the image of the NPA. The rules for the conduct of the inquiry make it clear that there is no onus on any party to discharge. The report of the Withdrawal inquiry into the fitness of Advocate Vusi Pakoli to hold office of November 2008 is instructive, in which it assessed the evidence and the weight to be afforded to it. And we then repeat what is said in paragraph 1 of the Withdrawal report. 41, sorry. I must emphasize that the analysis of the evidence was not done on the basis of any onus. I approached the evidence on whether any aspect relevant to the terms of reference had been established or not, without reference to any party bearing the onus to establish any aspect. Where the objective facts supported a particular conclusion relevant to any particular term of reference, I've gone ahead to make that finding. I've given due weight to the evidence of the witnesses that elected to provide oral evidence and be cross-examined in relation to a contested assertion made on affidavit by a person who had elected not to testify. I've also accepted, where appropriate, the uncontested evidence tendered on affidavit relevant to any findings that are made. We submit, Madam Chair, honourable members, that the evidence placed before this inquiry is circumstantial at best. Much of the evidence is of a general and unspecified nature, that the NPA has somehow been captured, the implication presumably being that Advocate Giba is guilty by association. There has been no evidence whatsoever of any involvement by her in the abuse of power and in the furtherance of any political agenda. And neither do any of the judgments containing the judicial criticisms make mention of this. While there may have been mistakes by her in her leadership or in decisions taken by her, that can never be sufficient to find that she is no longer fit and proper, bearing in mind the protected tenure of the Deputy National Directors. without a finding of mala fides, that impacts on the honesty and integrity, on her honesty and integrity, it would be unjustified to recommend that she be removed from office. To find otherwise would, with respect, be a grave intrusion into prosecutorial independence. In the circumstances, we submit that this inquiry, limited as it is to the decision of the majority of the SCA in the GCB matters, should not conclude that Advocate Giba is no longer fit and proper to hold office of the National Director. We deal with the legal framework and the test for determining unfitness at page 12 of our heads. Determining unfitness under a section 12(6) inquiry. We agree with both KSAC and FUL in their submissions. We, however, would stress, which, and I think at least here Mr. Naidu had accepted that in his own analysis and in coming to assist the panel to determine what framework should be followed, that he had not factored in section 42 of the Act, which provides for prosecutorial immunity, that whatever decisions they make, unless it can be demonstrated that they acted in bad faith or mala fide or something worse, that they were driven by ulterior motive, purpose or corruption, then those decisions are immune from scrutiny. And I think everyone will agree, and I'll be the first to say this now, that clearly, and we've seen our courts have, on the principle of legality, reviewed prosecutorial decisions where there was evidence to show that decisions were taken irrationally or for an improper purpose or motive. So we're not arguing that that's the end of the inquiry. We are saying that the panel will, one, take into account the objective facts, two, will consider whether there was mala fides or improper motive or purpose or even corruption or fraud, but three, will take into account prosecutorial independence and prosecutorial immunity. And we deal with that from pages 12 through to 15, and at page 16, under the subheading the appropriate test, we submit that the test which an inquiry under 12(6) must determine the question of unfitness must be fashioned against the principles of prosecutorial independence, immunity and accountability. In other words, the conduct justifying the removal decision must be grave. It must be such as to undermine the very constitutional premise on which the NPA is founded. So, Madam Chair and honourable members, we agree that at this end of the inquiry, as opposed to when you are appointed as an NDPP or an acting NDPP, that at this end of the inquiry is a lot more robust and the test more stringent. We can't agree, perhaps subject to a caveat, but we can't agree with Mr. Du Plessis' submission that even if you find that there's no reason to have her removed because she's not fit and proper, even if you find that, then somehow you can find on the basis of public perception or the public interest that is no longer in the interests of the NPA for Ms. Giba or any other senior prosecutor to stay in the job. Because this raises the debate which I thought we got great assistance yesterday from Mr. Naidu from KSEC in relation to issues of public perception and public trust. We know that by definition, a perception, whether it's a private or a public perception, is not always based on the facts. It's fueled by some other narrative, whether it's in the media, the electronic media, or the print media, or social media. These are the things that fuel public perception. And similarly, the public trust are also affected by what people read and hear in the public, that's in the public domain. You, however, as a panel, sit in a unique position that all the facts, all the relevant facts have been placed before you. So there's no need for you to consider the public perception or the public trust, save where this public perception and public trust have been informed by the correct facts. And we submit that we've demonstrated to the panel with respect that this public perception, which I summarized at the outset of my presentation, is not based on the true facts. Just to mention that we submit that the case of Nhlemeza is very different from the situation we're dealing with. There, General Nhlemeza was actually found guilty of lying and dishonesty, and the references to that case, to the extent that it may be helpful in terms of both for your own reference and for future reference, determining what a framework should be as to what constitutes fit and proper, is not however applicable in the case of Ms. Giba. For a start, one of the most distinguishing factor from Nhlemeza and Giba is that the complaints against Ms. Giba is rooted in 4 judgments. And then what we've heard in this inquiry are some further or additional facts to those 4 judgments. And that is really the framework within which, the factual framework which will guide the panel. Whereas in the case of Nhlemeza, there's a finding of mendacity, there's a finding of dishonesty and untruthfulness, and that's why the 2 cases are different. We want to be cautious in saying to the panel that because the SCA, and of course we know the matter is now on appeal to the Concourt on the 14th of March, we want to be cautious about saying that the SCA is now decided and that should be the end of the matter. We think, because of the opening that was provided by the SCA, that it is possible that where further and additional information came out of this hearing, and obviously that information must pass the test of admissibility, relevance, credibility, and so on. If there is, then it's quite possible that the panel, well, as we say, for example, the one with respect, slam dunk issue, if I may use my basketball parlance, or not my cricket parlance, is Advocate Kennedy saying, but my client, Ms. Giba, acted on my advice. She followed my advice. That, if I speak subject to correction to my colleagues, I think that hasn't quite come out in the court papers. So equally, there may be some other adverse evidence, adverse to Ms. Giba, which you would take into account. But it's interesting that Advocate Duplessis, Mr. Duplessis, placed absolutely no store on the SCA majority judgment. He makes the submission, which we all understand, that court decisions are binding, certainly on the parties involved in those matters. And in his own, I know this word narrative is getting a bad name, but in his own delivery, his own presentation, he keeps on referring to the 4 judgments where there is judicial criticism. But as things stand now, as I speak, there is an SCA judgment which has cleared Ms. Giba of any type of misconduct, and we would submit that you would lend a. I think the highest we want to put it is you would give a lot of weight to the findings of the SCA in that regard, and where there's any deviation from it, it would only be because there's information before you that may not have been before the courts. Is that it? Yes. Madam Chair, unless there's any questions or further questions, those are our submissions.
Thank you, Mr. Arons. Just one question. You say Ms. Giba acted on the advice of her counsel, Mr. Kennedy. How different is it from the notion or the situation where an officer follows, let's say, unlawful instructions from a senior? How different is it? Show me the difference. Yeah.
I think with respect, there is a difference.
No,
Yeah.
I wanted to show me the difference.
Yeah.
You obviously think there is a difference. Yeah. So
I
show
think,
me the difference.
I think without trying to avoid dealing directly with the question, the context is clearly important. In the case of whether or not a record should be filed, you, Madam Chair, and our colleagues, honourable members, and the lawyers in this room, you will recall that at the time there was a big debate, firstly about whether prosecution decisions are reviewable in the courts. They appeared, I speak subject to my colleagues on the other side and the side, they appeared to be immune from party review, or that's certainly what it says. But then the courts had established in the past, I don't know, maybe 7, 8, 9 years, that under the principle of legality, those decisions, the President's decisions, any decision, because it's part of the rule of law, is subject. So in the case of Ms. Giba, the legal advice at that time was, well, you don't have to provide the record, and these are the reasons, and she accepts that advice. Whereas I think a lawful instruction or an unlawful instruction, whether to follow it or not to follow it, I think it's in a different category. I'm unable to, at this stage of the day, think of a practical example. Maybe Mr.
Accept it.
But a client who relies on an advice from a lawyer in good faith shouldn't be held liable. The issue must be good faith.
I think with respect what Mr. Masuku, my colleague, points out is an important touchstone. At the end of the day, it's always going to depend on good faith or bad faith. If there's malice, or if there's improper motive, improper purpose, or of course corruption and fraud that influence the decision, I think that will also be an important deciding
In
factor.
this case.
And in this case also, there's no question, because of course Advocate Kennedy, as a colleague, he himself is constrained to conduct himself according to the rules of court, and he must conduct himself ethically. So the client, in this case Ms. Giba, is entitled to accept that his evidence is made in good faith, and she followed that advice. Of course, we also know that there are instances where she hasn't, like in the case of Advocate Algren, where she hasn't, and some other advocates are employed. But of course, then again, that's the right of the client. And again, unless some mala fides or ulterior motive or whatever can be attributed to Ms. Giba, she's exercising her right as a client, the right to choose which doctor to employ, which advocate to employ to do your case.
Thank you.
Thank you very much, ma'am.
Any questions? Question?
You tell the panel that you accept the scenario sketched by Mr. Naidu about the difference between the beginning and the end when you examine the question of fitness. And right now, before you finish, you make reference to the SCA judgment. And you say the SCA judgment has cleared Ms. Giba, and that we must take cognizance of that. And then you make the point that, and what I'm trying to understand is, the SCA was preoccupied, as it were, with her fitness to be admitted as an advocate. So when we examine her fitness in terms of Section 12(1)(c), where do you see what we are supposed to be looking at and what we are supposed to do, and the difference between the two? And whether there is a difference or there is no difference in that inquiry.
I think that's an important distinction, but with respect, we say, at the end of the day, on a proper analysis, a distinction without a difference, because your fitness as an advocate is predicated upon integrity and honesty, very importantly. And to that extent, the SCA has found that none of the conduct complained of amounts to dishonesty, and it also doesn't impugn integrity, as that's part of the test. Now, what we have here, and we've dealt with it from page 12, determining unfitness under the 12(6) inquiry, because additionally you have independence, you have experience, and then you have conscientiousness and integrity. And in addition, under the Act, what we would submit also qualifies the test adopted in the GCB cases is issues of independence and immunity. But having said all that, I'm inclined just to the view that something bad needs to be demonstrated. You were dishonest because you lied. Now, we can't have degrees of dishonesty. Either lied or he didn't lie. But for example, where malafide is demonstrated, malafide is demonstrated, ulterior motive is demonstrated, ulterior purpose is demonstrated, or there was worse, an act of corruption, then all of that goes to integrity and honesty. And they will impact similarly whether you apply the test for the fitness of an advocate to be enrolled or to practice as an advocate, or whether you practice as the head of the NPA. That is why, in addition, the 12.6 inquiry also talks about other categories of unfitness: misconduct, good old-fashioned misconduct, incapacity. You're incapable of doing the work. So you're honest, you're a person of integrity, but shame, you're just not able to do the job. And that would be a grounds for removing you from the office. And of course, there's ill health. So there are discrete categories, and then the fitness and properness it's more located on honesty and integrity and those kinds of issues.
So your view is you need no more to serve in the position that Ms. Giba is serving at the NPA than you need to be a member of the bar. You're not saying that?
Well, for a start, you must be admitted as an advocate. So if there's a finding in the courts that you're not fit and proper, and therefore you can't be admitted as an advocate, that's the end of the inquiry. But for what we are not saying, because we think you have more latitude and a bit more discretion, because you also now have further facts and additional facts, is that there are also other issues. And to that extent, Mr. Du Plessis could be right. There's issues of public trust, but then they must call the witnesses. And they must say, you know, they're calling a witness. I brought this case to the attention of the police or to the NPA, and you know, nothing has happened, and there's just a whole string of members of the public, for example, and they are a public interest organization, but there was no evidence from them to show the public perception which they say exists, and the public distrust and the lack of public confidence are based on these 4 cases. And that's Mr. Du Plessis' submission. And we said those 4 cases, subject only to what the Constitutional Court may decide, have been dealt with decisively by the SCA. And then an additional argument he makes is, well, if you can find fitness and properness, but in addition, if you still find that it's not a good idea to have a person there like Ms. Giba because of a lack of public confidence, public distrust, you must still remove her. That may be possible, but then the facts must be placed before the inquiry, and those facts we submit are not there. And I think we've with respect demonstrated that those facts are not there.
Thank you. Thank you, Mr. Aransa.
Ms.
Oh, no, I
Vilakazi was
think
going to ask me a racketeering question.
she has more questions. No, please.
I do, however, still remember my one request to you, which the last time we spoke about it, you said you would require more than 5 minutes, and we left it hanging. I think it related to Boyson and the incident about the charge sheet. That part is the part that was never dealt with.
Can we end up There's a constitutional court decision of, what's that guy with, what's it? Savoy. I think the Savoy Constitutional Court decision explains how those charges and racketeering, the offense, how that works. Perhaps we can make that available if it's not available yet.
So you will make that available. Thank you. Mr. Rip.
Thank you, Madam Chair, and honourable members of the panel. We have prepared written submissions which have been made available to yourself and should be in front of you. I'm going to take you through them, but we're not going to read them out. I'm just going to stand still at certain pages and emphasize certain areas. You'll see that it starts off, the first few pages just sets out the basic referral and where the inquiry is supposed to be at this stage and what it is that you have to try and do. And the first place I wanted to stand still for a moment is at page 4, paragraph 4, what I've called relevance of evidence. And this touches to a certain extent on my failed amicus curiae application a few days ago. In essence, what we're submitting here is that, and you can read it in due course, but what we are saying to you is that this inquiry is an inquiry which has been instituted by the President in accordance with the National Prosecuting Authority. And therefore, the inquiry's statutory basis for doing its work is fairly defined. We know what it is, we know where it comes from. And unlike Mr. Du Plessis, who suggested a whole host of other, what he called objective facts which I'm not sure what he meant to say with it, we say that the only thing the inquiry can do is, on the basis of the Act, make a finding whether or not they are fit and proper people, taking into account the aspects set out in the Act and obviously the interpretation issues which have been set out. And interestingly enough, yesterday Mr. Naidu's evidence, and I agree with Mr. Orenser that the evidence we believe was very, very useful. One of the things he said which ties in with what was related to my objection a few days ago and the point I'm trying to make now is that the only way that people who've been appointed in terms of a presidential appointment through the proclamation, such as Advocate Mokgoro in this case through the proclamation that took place in November 2011, making him a special director. The only way that such a person can really be disciplined is through a section 12.6 inquiry first taking place and then the President exercising his discretion, because it then starts falling, is that phrase, at the pleasure of the President. Obviously the President's pleasure is tied up with administrative and constitutional red tape, but it does fall within his purview. The point we wish to make, flowing from that, and which we set out in our papers, is that accordingly we would submit any activities by Advocate Mokgoro before his appointment as a special director and putting him within the purview of this inquiry and a section 12.1c inquiry through section 12.6 can only start once he occupies a position that entitles the President to call such an inquiry. In other words, before the proclamation in November 2011, the positions he occupied previously as head of the DSO, the Scorpions, or as the other positions he might have held in the organization would have been covered by the organization's disciplinary code and normal code of conduct, and normal disciplinary steps would have had to have been taken against him if it was felt that he was guilty of any misconduct or any activities that deserved sanction from the National Prosecuting Authority. And it's on that basis that we submit to the inquiry that all of the mud that has been thrown at Advocate Mokgoro by certain of the witnesses relating all the way back to 2005 and allegations that people were unhappy with him at the Scorpions in KwaZulu-Natal, the advocate Harry Null allegations, the Celebi allegations, all of that with respect are completely and totally irrelevant for the purposes of this inquiry, because this inquiry has got a fixed ambit, and we say and we submit to the inquiry within which it has to operate. We do touch on those aspects in any case. We plead over in case the inquiry disagrees with us. So we have touched on some of those aspects. But that would essentially be our argument, because only once you are one of the presidentially appointed people can this inquiry from the president start considering what you've done. And that's the point basically that we set out, Madam Chair, in paragraph 4 and paragraph 4, pages 4, 5, and 6.
Mr. Rib, without wanting to throw you off on your, with
Not at
your
all, ma'am.
argument,
Yes, ma'am.
I accept that you should have been paid, otherwise I would not have stopped you the other day, because you're an amicus. But if I may, before I get to you, can I say, Ms. Bauer, I was saying to Ms. Budlander, you don't know how to whisper. I get it, and I'm on, no, I know you're not saying anything now, but you're whispering, just, the strange thing is I'm hard of hearing, but I get disturbed by the two of you this side of the table. Having said that,
I worry that it gets onto the record and we can't distinguish what is relevant and what's not.
no, you whisper very badly. I will teach you how to whisper. But Mr. Rib,
Yes, ma'am.
what are we to make of the first sentence of the terms of reference? The fitness of Mr. Mokgoro to hold office as a prosecutor, and then it goes on to say, and in particular, because that first sentence talks to him just being a prosecutor.
Madam, we would say that that means as a prosecutor, obviously, apart from being the Special Director of Public Prosecutions, he's also a prosecutor. So he has both a very large administrative managerial role, which we've heard of, and he can also appear as a prosecutor in court. So the misconduct complained of, or what is investigated would cover both areas, not just his titled role, but also his activities as a prosecutor. Because as I understand it, right up to the National Director of Public Prosecutions, all are still prosecutors with the prosecutorial obligations and possibilities attached to it. So I think it's just I don't think it stands as a separate investigation that you must look at him as a prosecutor since he started prosecuting in the Ciskei at the age of 19 or something. As we know, Advocate Mokgoro has been involved with prosecutions in one form or the other since he started studying and after leaving school. I think he still studied through the Department of Justice system, through NISA. Did he go to university full-time? 14 After he left university, I wasn't quite sure if he studied through the justice system or not, because I know a lot of the prosecutors did it through NISA in the olden days as part of a sponsored system. But he first went to university, but since he left university, he's been prosecuting. So we would submit that it's only once he reaches this level, because if he did something wrong as a prosecutor in the Ciskei in 1991, then there's a code of conduct which deals with a prosecutor at that level, and he should have been prosecuted. And my recollection is that those inquiries have to take place within a limited period. If I'm not mistaken, it's 90 days you have to institute. So you can't not take disciplinary action against someone for years, then all of a sudden decide, well, now we're going to prosecute you because you've made us angry. And that would be our answer to that question, ma'am. So on that basis, we would say the date of relevance would then effectively be, I think it's the 27th or 28th of November, 2011. We then say that We deal a bit with the standard of inquiry, but I'll get back to that, because what I want to first touch on, ma'am, is what I've put at page 8, paragraph 6 of my heads, what I've termed the evidence and the narrative, which could almost be a book about this hearing. And I'm not going to try and use the word narrative too much, but what I say to you is that we say in paragraph 6.1, and that's what I want to just read out, we submit that what the inquiry respectively has to do is to separate the actual evidence that has been provided to the inquiry from the narrative that I shall define hereunder. And then I say the narrative with respect clouds and obfuscates the real inquiry here, namely that Advocates Giba and Morebi, in collusion and in concert, acted with mala fide intent to protect Lieutenant General Mdluli from being prosecuted, and that such mala fide actions is what really constitutes the complaints against the actions of Advocate Mokgoro. This narrative, which has had much play in the press and which press reports and versions has created, we respectively submit a false opinion and public perception as to the activities and intentions of Advocate Mokgoro. The suggestion is that Advocate Mokgoro, in order to protect Lieutenant General Mdluli, and it would appear as per the narrative, as a favor to the then President Zuma, with the assistance of Advocate Giba, the then acting National Director of Public Prosecutions, deliberately and in a nefarious manner set about withdrawing criminal charges against Lieutenant General Mdluli, with the sole objective being the achievement of this irregular result. We submit that should this narrative be removed from the consideration of events, then all that is left is an action by Advocate Mokgoro, which some parties have criticized and disagreed with, whilst other parties seem to support, that in itself would not justify any interference or finding by the inquiry as against Advocate Mokgoro. Now, against that backdrop, Advocate Orange has already touched on the same argument to a large extent on behalf of Advocate Giba. So what we need to do with respect is now to consider because quite a few, in fact, I think all of the actions as far as Advocate Giba are concerned, Advocate Mokgoro are concerned, relate to his activities surrounding the Mdluli provisional withdrawing of charges, the meeting of the 5th of December and the 9th of December, and the evidence that flows from there and the activities related thereto. If we have to sit back for one moment and look at the picture from a different perspective, and to say, when Advocate Mokgoro did what he did in making the decision on the 5th of December to provisionally withdraw the charges, and then on the 9th of December reaching the definitive agreement, because that agreement everyone is in agreement about. Advocate Mnzinyati, Advocate Breitenbach, all sides of the coin agree what the agreement was on the 9th of December. Namely, that there was a provisional withdrawing of charges, that there would be further investigations, that Advocate Breitenbach was tasked to look into the matter together with the IGI, and that when the matter was ready to proceed, the matter could be placed back on the roll. If we just had to stop there and look at that aspect on its own, ma'am, without looking at anything else, then we would submit there's not a single issue there that should raise a red flag or any concern or consternation to anybody. It was submitted that it's common in very difficult matters that are going to have difficult trials to not rush to court, to get all your evidence in place. There was, on the basis of Advocate Mokgoro's provisional withdrawal of charges, there was still every prospect, as we sit on the 9th of December, of General Mdluli still facing prosecution. He had not been told he would not be prosecuted. No promise had been made that he would not be prosecuted. The conference where President Zuma was apparently seeking assistance was in December of 2011. So by the time the conference arrived, General Mdluli had not been set free from any prosecution. So any favor to President Zuma in whatever form that might have been, as per the narrative, has not occurred. So where is the damage as we sit there? It's easy now to fast forward 8 years as we are now, ma'am, and say, well, General Mdluli's never been prosecuted, and as Colonel Rulofse tried to suggest, and I think someone else who escapes me now, well, if it wasn't for that provisional withdrawal, you would already have been prosecuted and found guilty. Well, that is a huge quantum leap in the matter. If it was as simple as that, then we really don't understand why General Mdluli has not yet been prosecuted and not yet been convicted, notwithstanding the fact that our client has had nothing further to do in any manner with the further prosecution. So obviously there is some other problem lying outside of Advocate Mokgwebi's decision or influence. And a number of things happened at the time which in any case delayed the prosecution, just to be fair. The first is that Colonel Rulofse did say that at that time, it was in December, they became aware, or late November, early December, they became aware of the Singapore and Hong Kong trips where there were suggestions of corruption because General Mdluli took his girlfriend or unauthorized people at state expense on trips. And then it also was found out a month or so later that it appeared that the main witness in the corruption sale of the motor vehicle case had been forced by Barnard to make a false statement, so his evidence was untrustworthy. So if they had in any case gone to court, they would have had big trouble and probably would have had General Mdluli acquitted. All of these factors lead thereto that the matter is then not prosecuted. So what is it that Advocate Mokgwebi did so terribly in response in regard to the withdrawal of the charges? And where the narrative becomes important is if I can take you to top of page 10 of our submissions. This is, we respectfully submit, where Advocate Breitenbach started to play a huge role in the narrative that was created. And I'm not attributing the whole narrative to her, but certainly she had a role to play with it. And that narrative, till today, was being fiercely propagated by Mr. Hofmeyer, for instance. And I'm quoting from the transcript. And I asked Advocate Breitenbach that you used words such as nefarious, there were appointments for ulterior motives, because he suggested, and this my learned friend Advocate Orange has dealt with, she seemed to suggest that the very fact that Mokgwebi and Giba were appointed to their positions was all part of the Mdluli Savior program. Appointments for ulterior motives, inference would be run, etc. Am I correct? Just help me if I'm wrong, that you had the impression that the Mdluli prosecution would never happen, that someone somewhere would ensure that it would not happen. Advocate Breitenbach said, well, I had a fear that that was going to happen. I did not have a view that that is what would happen. I suspected that that is what is being attempted. I was quite determined that the opposite would happen. And that's significant, man. We'll get back to those words now. But there was a case to be answered, and that Mr. Mdluli would answer the case. If he was convicted, so be it. If he was acquitted, so be it. Then I said, so the aspect that we are struggling with is, why did you have this feeling? Because we do not know where that feeling comes from. And Advocate Breitenbach's answer was, Mr. Rip, I've been a prosecutor for 26 years. I'm not particularly gifted, but I'm also not particularly stupid. You can call it a gut feeling. You can call it evaluating the landscape. You can call it observing what is happening around you and not be oblivious to it. All of those things. So I cannot say to you one thing, and that is the reason. A variety of things were happening in the NPA. A variety of things were happening elsewhere. It all built up to this feeling, and events have borne it out. I'm sure you will agree Mdluli has not been prosecuted. So when directly asked for evidence, she couldn't give any, and the same happened with Advocate Ferreira. But the importance of what Advocate Breitenbach says there is that she would not allow this not to happen, was that Advocate Mokgwebi gave evidence at some stage that when he was approached by Advocate Breitenbach, and there was a conversation where she said to him, but if you do not reinstitute the prosecution, there will be a media backlash. And Advocate Mokgoro said, well, he was not going to be intimidated by that. But what's important is not long after that, the media backlash did in fact start with leaks coming out of the National Prosecuting Authority, and that media backlash and those leaks has built the very narrative over the last 7 years that we are now dealing with. And whilst we will agree with Mr. Naidu and Mr. du Plessis that public opinion and public perception can be in a very important role, that public perception must be taken into account when one considers the activities of someone. So if you find that Mr. A did X, and we know that Mr. A did X, and the public perception, because of what he did, creates a very bad image for his organization or for the NPA in this case, then that certainly is, we would submit, something one could take into account, because his activities have undermined the performance of his duties and the performance of the National Prosecuting Authority. But with respect to a person cannot do it the other way around. You can come along and say, there is a public perception. Such public perception is very bad. Such public perception sees the NPA as being a weak organization. And because of that public perception, we have to remove certain people out of the organization, because that will cure the public perception, and then the organization will work better. With great respect, the tail cannot wag the dog, and whilst the tail is very important, it has to be seen in the right light, and I think Advocate Orense dealt with that as well. So on page 11 and 12, I just set out what I've been telling you now, and submissions we've been making up to this point. The other aspect we'd like to just mention, which isn't specifically dealt with in this document, is that apart from the withdrawal of the charges against Advocate Mdluli, there's not one, Advocate Mdluli, sorry ma'am, the choir master has me. General Mdluli.
Your client found it very funny, Mr.
Thank you, ma'am. I have been caught up in that. I've been captured by the narrative, ma'am. The General Mdluli, I've forgotten what I was going to say to you. Apart from the General Mdluli issue, there's not been one single other instance of evidence suggested or referred to as far as Advocate Mokgoro is involved, where he has withdrawn charges in dubious, controversial, suspicious circumstances, or in any other way appeared to have favored any other person other than this one instance. I'm not saying that person was favored, but other than this one instance of which has become controversial. In fact, in the Busasa matter, when he received representations from two of the witnesses who were called to give evidence or provide documents in terms of the Criminal Procedure Act to a magistrate, he rejected their representations. And I'll get to the Greasy matter now. When he was approached by the policeman between February and April of 2012, and the intelligence policeman whose attorney, who has a name I'm not even going to try and pronounce with respect, ma'am, because I know I will get it wrong. The Polish surname, I think it is. He didn't agree with their representations and say there would be no further investigation. And in fact, I refer to that letter in particular in my document, where the letter from the attorney in fact says that since our visit to you and our representations, not only has the police investigation not stopped, but it has intensified and continued unabated, which we would submit supports Advocate Mokgoro's version that the message was sent back to the police: continue with your investigations, go and get what I think the evidence is you need to properly prosecute General Mdluli. He never tried to stop any investigation by the police. So what we're left with is this big argument about whether or not at the time you made the provisional withdrawal, there is ma'am, just the name of the attorney appears at page 23 of my document, and where what I've just mentioned to you also appears at page 23, paragraph 6.29, just for reference purposes. And thank you to my learned friend. And he never agreed with their, so we got the big debate, I was busy saying, ma'am, that, and members of the panel, about whether or not there was enough evidence at the time to constitute a prima facie case to continue with the prosecution at that very date. That goes back to the evidence surrounding the confidential evidence and the evidence that's coming out of the intelligence sector. Now, ma'am, I deal with this from page 16 of my submissions, of our submissions, and I point out at paragraph 6.16 that we believe quite fairly all of the witnesses agreed, both Breitenbach and Ferreira as well, that prosecutors have different opinions at different times about whether a matter should continue with the prosecution or should not continue with the prosecution. And that is very, very important in the context of what we're dealing with in this inquiry and the prosecutorial independence issues that have been raised by numerous of the speakers before me, and I think they have all been covered sufficiently, and I believe Mr. Naidu covered it particularly well yesterday. And we agree with that aspect. So the question really has to arise, can this tribunal or this inquiry, on the basis of the evidence before it, find that when Advocate Mokgoro took the decision on the 5th, which decision was in any event superseded by the decision on the 9th in the exact format of it, to provisionally withdraw the charges, can it be said that that decision constitutes, or that activity constituted, any of the type of matter that would make him not a fit and proper person? And we would submit that the only way that could be so, if this tribunal can find on the evidence before it that it was done male fide, in corrupt circumstances, and due to gross incompetence, and in an unconscionable manner, which are more or less all the same thing when one comes to this particular inquiry. And what Advocate Mokgoro said was that he had considered the docket. We look at the trail of events. There were written representations. He didn't hide the written representations away and take a decision behind anyone else's back. He wrote to the prosecutor, Advocate Smith, and said, "I've got these written representations. Here they are. Please give me your comments and the docket." He got some comments he was not happy with. He didn't get the docket. He wrote again and said, "Well, I'm not happy with your comments. Please deal with it in more detail, and I want the docket." Then he got a second response. He considered the docket. He went and saw Advocate Mdluli in what he thought was sufficient for a consultation. We all know now that's not sufficient for a consultation. And then he sat down and considered the matter. Just on the consultation point, ma'am, it was clear from the evidence that was given by Advocate, I think it was Chris Jordan, who was the first head of, who occupied the position of Advocate Mokgoro before he did, that Chris Jordan's evidence was unequivocal, that he would take decisions as to how prosecutions would take place. He would inform the directors of his decisions, and no director ever challenged him as to the correctness of his decisions or what he was doing. Now, ma'am, that might not have been technically in accordance with the Act, but that certainly was the ethos and the culture within which that division worked at the time that Advocate Mokgoro inherited it from Advocate Jordan, and that is what he then also did. So in the sense of where one wants to throw blameworthiness at someone, we would submit that it's understandable where you got that approach from and why you believed it was the right thing to do in light of the evidence of Advocate Chris Jordan. We then submit to ma'am that he then wrote the consultative note on the 5th, which was an internal note, not meant for public consumption, and he decided on the basis of what he believed to have been very important documents that were required. Now, it must also be recalled that Advocate Mokgwebi's evidence was that as head of the Scorpions in Natal, which as we know has always been a hotbed of intrigue and political activity, he was involved in many cases where you had to prosecute politicians and policemen because of our unfortunate history of our country, which left us with the remnants of the ongoing feud between the IFP and the ANC and other groups in Natal, which made it a particular hotbed. So we would submit that he was more than most aware of the type of problems one could arise with political or police type prosecutions and how careful one had to be to make sure you had all the right evidence before you went on. And when we look again at what he's saying, we would submit that it is completely reasonable, the approach that he has adopted. Some might think it's wrong. Maybe if we went through a whole trial on that, we might even find it's wrong, although we would submit it wasn't. But he said quite simply there were two things that concerned him. The first was that the loan had to be shown to be an unauthorized gratification, and it appears that all the other people who disagreed with him missed the bit about unauthorized gratification. Normally it'd be quite simple. If I'm working for an organization, I work for Pick and Pay, I get a loan that I'm not supposed to go, you phone Pick and Pay and say, did Mr. Rip get his loan, was it authorized, and they'll give you the document. In this case, the gratification has to be authorized or not authorized by the intelligence community of the South African Police Services. So the only way to know whether or not that was authorized or not authorized is to get evidence from the intelligence community or out of the Inspector General to show that this was an unauthorized gratification. If it was, and Advocate Mokgwebi accepted that it was suspicious. We all accept it. I can't argue that it was not suspicious. That the whole transaction certainly was suspicious, and that's what led to the initial investigation. But that's different, being what's suspicious, to being able to go to court and start a trial where you have to prove and win a trial, or the idea is to the best of your ability to win a trial beyond reasonable doubt and get a conviction. Otherwise, it's just a waste of everyone's time. So that document was not forthcoming, and Advocate Mokgwebi believed that documents like that could be obtained from the Inspector General through the section he referred to. And I refer, Madam Chair, to the affidavit that was handed up, and I refer this to page 21 of my document, paragraph 6.27. This is the affidavit that made its appearance last week, and I read quickly. Further, in an affidavit supplied by one Jashri Govender, a legal advisor in the Office of the Inspector General of Intelligence, which affidavit was made on 21 February 2019, Ms. Govender disputes certain of the evidence of Advocate Mokgwebi. She does, however, state the following. Further, I vehemently deny that I had indicated that the legislation governing the OIGI was in the process of being amended to exclude the investigations. This would be anomalous, as by its very nature, the mandate of the Inspector General is to monitor the activities of the intelligence services through investigations. This is especially germane to the discharge of the complaints mandate. And this is exactly what Advocate Mokgwebi was saying. Saying there's a complaint against General Mdluli. He is part of the intelligence sector, police intelligence sector. the investigator or Advocate Breitenbach or anyone can make a complaint, and they have to do it in investigation. The automatic knee-jerk reaction by a number of the people that when Advocate Mokgoro said that must be referred to the IGI for investigation, that they do not do police investigations, is completely incorrect. It was this type of an investigation that Advocate Mokgoro had in mind, and that was his evidence.
I understand, Mr. Rip. Are you saying that a complaint of that nature is the same as a complaint that as an A1 statement, as it were, that institutes a criminal investigation, that the two are the same? Is that how?
No, I'm not saying the two are the same. A criminal complaint is a criminal complaint, ma'am. I'm struggling to hear you, ma'am. Sorry. ma'am.
Sorry, they had before them the criminal complaint with
Yes.
the docket. And your issue here is that when she says that through investigations, are we talking about the same thing? I'm trying to understand.
No, ma'am. It's two different types of investigation.
So that therefore they do investigate.
They do investigations, ma'am. That's the point of what I'm trying to show you with this affidavit that came to us on the 21st of February. What everyone has assumed is when Advocate Mokgoro said refer it to the IGI, he meant they must do a criminal investigation on behalf of him or on behalf of the police. They cannot do that. We're not making the submission that they can do a criminal investigation. But if a complaint is lodged against a member of the security service or cluster, they can investigate such a complaint. So the complaint would have been that General Mdluli has defrauded either the BMW garage or the South African Police Services funds, and that they must then investigate this. The problem lies therein that how do you get the result of the investigation, and there is an answer to that as well. If I'm not mistaken, it might be Section 42 of the Constitution, and there are the Intergovernmental Dispute Resolution Act as well. There are provisions in terms of which different divisions of the government are compelled to give, to assist one another and to give assistance to one another in trying to resolve issues. And there's also a whole process in terms of which documentation can be declassified. Now, the evidence by General, now I'm getting confused again, by Advocate Mokgoro, and I think it was also confirmed by, it might even have been Mr. Hofmeyer, one of them who referred to the Parliamentary Standing Committee, that this has got up to the Parliamentary Standing Committee about the declassification of the documents that relate to the Mdluli activities within the security sector, and that the current Commissioner of Police has still not agreed to the declassification of documents and the like, and that would appear to be the problem. So when Advocate Mokgoro said, ask them to investigate, it didn't mean a police investigation. He meant their own investigation, and we will get the documents from them. There's also the Governmental Framework Act 13 of 2005. I've got two instructing attorneys. Thank you, ma'am. So Intergovernmental Framework Act, actually. So that's the point we want to make. So to do a request like that wasn't ridiculous. And when one looks at the representations from the 6 policemen represented by the attorney, they are saying your investigations, and by trying to open up the documentation from the security cluster, you're not only going to embarrass us, you're going to embarrass the whole country, you're going to make us liable to terrorism. So it's clear that there are confidential documents that are needed and that are not available and that people don't want to disclose. And the same would be in respect to the vehicles. You could say, well, we've got the slips to say, here's an invoice, we buy a 3 Series BMW. But the company that bought the 3 Series BMW is a front company. It is a police Secret Service front company that buys the BMW. The BMW is then registered. So if I get the number plate and I go and look, I'll find it belongs to whoever, it's like in the James Bond movies, and we find the BMW belongs to so-and-so exports, and we don't know it's actually a police vehicle. Now to get behind the names on the invoices and to show again that that were state funds that were being used to benefit Barnard and or Mdluli, you need to actually have the documentation showing who those companies are and the trail of money. And that is what the whole issue about the Inspector General and the classification of the documents was about from Advocate Mokgwebi's side. And that we would submit to the panel, Madam Chair, cannot be seen as anything nefarious, mole fide and the like. It only becomes those things if you add that dreaded narrative word to it, ma'am. Then all of a sudden it takes on a completely different perspective. So I've dealt with all of that in length in my submissions. We then go on to page 24. I summarize some of the evidence. I go to page 26, ma'am. We just look at paragraph 13. We submitted under cross-examination. Advocate Ferreira conceded that authorization documents from crime intelligence for the purchase of the 2 BMWs was not in the docket, and that if it was in the docket, it would have had to have been declassified first. And this just ties in with what we are saying in respect of this. At page 27, ma'am, I touch on Advocate McAdam. Now, Advocate McAdam, I'm stepping off the Mdluli issue, and with our final submission on that is that whatever the criticism might be, whatever the disagreement is, it cannot and it does not reach a point where the panel can find that anything was done that justifies any intervention by this panel in terms of the Act. Advocate McAdam's criticism, we would submit, Madam Chair, was actually clouded by his grievance. He actually appeared as a person with a grievance, and his grievance was he was given this task of looking after the foreign bribery cases, and just when he thought he was doing a brilliant job and had achieved much for South Africa, it was torn out of his grasp, much to his dismay and his belief that the country would now fall into the realms of embarrassment and the like in the future. Now, ma'am, first of all, he only was in control of the unit of those files for a period of about 8 months. And he had no idea what happened after 2014. And it doesn't appear that Advocate Mokgwebi was responsible either for him getting the files or for the files being taken away from him. So I'm not sure why he had such a serious gripe with Advocate Mokgwebi. Advocate Mokgwebi then showed, and we used the same hearsay document I objected to earlier, from the internet, which was the independent non-government organizations worldwide report, to show that South Africa are no worse off than we were in 2014, and it appears that from the evidence of Edmund Mokgwebi, which wasn't challenged, that we have now got to the point where prosecutions are actually about to be instituted. But what is of great interest in that report is the company we keep. And if you look at the company we keep as being a moderate enforcer of the Act, we are with well-recognized international so-called first world countries who are no better in doing this than we are. In fact, Israel jumped 3 positions in ranking because they managed to do 1 prosecution. And that's the point of what that report is. We haven't been damaged. Our credit rating hasn't been taken away. Eskom, I think, does that for us all on its own. And so Advocate Mokgwebi can't be held liable for any of that, and his position hasn't been responsible for anything that we submit entitles the panel to find that he's not a fit and proper person. We touch on Colonel Rolofson. I wasn't here, so I had to depend on other evidence, but much of his evidence, I saw some of the cross-examination related to Advocate Giba and his investigation into the Durban flight. And then we've summarized Mr. Willie Hofmeyer's evidence as well. We would submit that much of the evidence by Mr. Hofmeyer that involved Edward Mokgoro falls in the period and his hearsay evidence that flows from the period before his appointment as a special director, and we would submit falls into the period prior to the factual investigation of this panel. Mr. Hofmeyer, rightly or wrongly, is also seriously aggrieved. And Madam Chair, what is clear is that, and we make the submission somewhere in our submissions, that we think the single factor that probably has done more to damage the NPA has been the almost conveyor belt change in its national directors. It's very difficult for an organization where the national director continually gets changed for the people who have to report to him or responsible under him to have a sense of confidence, to have we would submit, and these are just submissions we make. We would say that the panel can take it from judicial cognizance, would have a feeling of mutual working. It's clear that cliques arose, that different people pursued different angles. Mr. Hofmeyer and Advocate Mshe went off on their own. The spy tape drama, Advocate Breitenbach had her view that she wouldn't allow the Mdluli matter to be left alone with all the consequences that had. So we're not trying to lay blame at anyone's door, but this is what happens when you have a disharmonious organization with no effective top structure. People need to know where they're going, they need direction, they need a common vision, and that's clear that wasn't happening. And that played heavily into the narrative as well, we would submit. Mr. Hofmeyer was not a good witness. If I was arguing a civil trial, I would say his evidence could be rejected. He wasn't prepared to make the simplest of simple concessions, and he definitely had his own agenda, but we do not believe he took the matter any further as far as Advocate Mokgoro was concerned. Then there's the Celebi matter, which was one of the issues which Mr. Hofmeyer did make much of. We deal with it page 32 of our heads of our submissions. And the first point we'd like to make it is it falls in the period we submit. It's not relevant to this inquiry. But should it be found that I'm wrong in that matter, we do not simply understand how the actions of Advocate Mokgoro in making a confidential affidavit 5 months or 4 months before the urgent application of then National Commissioner Celebi can be seen as being part of a joint effort to support Celebi in his fight against the National Prosecuting Authority. Because again, if I can quote from my learned friend Mr. Orence's crystal ball example for Advocate Giba, Advocate Mokgoro must have been sitting around the same crystal ball to know that when he made that affidavit, all these events were going to take place, and in 4 months or 5 months' time, Mr. Celebi would latch onto some of the comments in his affidavit in an attempt to use them. There's been no criticism of the content of the affidavit. The affidavit is simply, I believe, I'm not sure if it was Ms. Vilakazi or someone asked a question about the content of the affidavit. It was just a recordal of what happened in the July meeting for purposes of the investigation of the parliamentary task team. It didn't come to any conclusions, it didn't blame anyone, didn't point fingers at anyone. It it was the interpretation ever that Mr. Celebi's legal team wished to place on the events that then turned it into a tool by them. And then, as he indicated, he only gave evidence at the Celebi trial because he was subpoenaed to do so. He cleared that with the then National Director of Public Prosecutions and said, well, I've received this, what must I do? And the answer was, well, it's a lawful legal summons to appear in court. You would face sanction if you did not go. So he went. He said if that's the first time he met Mr. Celebi, first time he met the legal team, it wasn't arranged with him. And if we read Judge Joffe's lengthy judgment, the relevant portions, he didn't find anything strange about the evidence that Advocate Mokgoro gave. It was in accordance with the affidavit he'd given previously and an explanation of that. And that's the sum total we would submit of those allegations. We then set out what we consider some of the legal principles, and then from page 36 we do a further analysis of the withdrawing of the charges. The last aspect we'd like to deal with is at page 38, and that's the Greyling matter. As we're all well aware, Mr. Greyling somewhere in his state capture evidence referred to advocates Mokgoro and Giba. We would submit, first of all, Madam Chair and honourable members, that his evidence is hearsay. His evidence is that Mr. Mnti told him that the documents he was giving to Mr. Greyling he obtained from one or more, all of the three mentioned people, that's advocates Mokgoro, Giba and Ms. Lepinka, and that they were getting this gratification of 120,000, and disappointingly for my client, only 10,000 for these documents. And that is what that's a classic example of hearsay. It's not as some of my legal colleagues believe, that if you've been told it yourself, then it's no longer hearsay. And so we don't know what Mr. Mnti was telling Mr. Greyling was true. We first of all don't even know if Mr. Mnti told Mr. Greyling that, and we couldn't test that because he didn't come and give evidence. But what's more importantly is we don't know whether the version that Mr. Mnti, for all we know, Mr. Mnti was putting all of the money in his own back pockets, into his pocket, and he was getting the documents somewhere else. We don't know the answer to that. But what we do know is that both advocates Giba and advocate Mokgoro have vehemently denied it. Advocate Mokgoro used a very graphic description about it would be akin to spitting in the graves of his family, his grandparents, if he was to do something like that. And there simply is nothing other than this hearsay, untested, uncorroborated statement by Mr. Greyling in support of that. And it's certainly not something that we submit could in any fashion or form be used against Advocate Mokgoro in these investigations. We then get to the conclusion we submit to you, Madam Chair, that when one actually analyzes the basic complaints, there's nothing here that reaches the required level of blameworthiness, mala fides, dishonesty, all of those factors that justifies the interference by this, well, I'm not saying interference, but the finding by this panel that Advocate Mokgoro is not a fit and proper person. In conclusion, just want to touch on some of the aspects of Mr. Du Plessis' the FUL submissions. The one submission that he made was that because these matters were not appealed, they've now become effectively cast in stone, and we are stuck with the findings there, and those findings on themselves are what he called one of his 4 objective facts, and those objective facts are sufficient to torpedo our boat. Now, first of all, Madam, what has not been appealed, the finding that President Zuma did not act properly by not instituting a Section 12 inquiry has been overtaken by the fact that the replacement president did institute a Section 12(6) inquiry. So why on earth someone would go and appeal the finding against President Zuma as to whether it's right or wrong when the next president has done exactly what the fool's complaint was that was not done? I think such a person could be charged for reckless expenditure of our nation's funds. And secondly, the next question was that there was another appeal, but that's also been overtaken by the fact that this inquiry has in fact been instituted. So there's nothing to it. The fact that they weren't appealed, there's nothing to it. Furthermore, there's another legal problem with Mr. du Plessis' submissions, is that whilst the lower courts might have made some findings critical of both Advocate Giba and Advocate Mokgoro, you cannot appeal the findings, you cannot appeal the reasoning, you can only appeal the order. So if the order was that the withdrawal of the charges was unlawful, even if you win on appeal and overturn, it doesn't mean that the findings are changed. The next court may or may not deal with it. We would never know how the next court would deal with it. So that is one of the problems a person faces continuously when courts make statements along the way. And what we're trying to submit to the panel is that it really doesn't take the matter any further, the lack of appeals, because we are here dealing with the real McCoy, and this is what the panel has to face and the panel has to deal with. There's one, sorry, my Advocate Mokgoro just pointed out to me, I didn't deal with the standard of inquiry. That appears at page 6, paragraph 5 of our submissions, man. And we submit, whilst obviously when it comes to questions of integrity and honesty, it sort of speaks for itself. We do not know how it can be that this inquiry has to apply a higher standard than the Supreme Court of Appeal has to apply on whether or not a person is a fit and proper person to be an advocate. They're different tests. Some of the tests, as Advocate Arons has pointed out to you, would not be considered at all when you're deciding whether you're fit and proper. Misconduct and incompetence and unconscionableness might not be a fit and proper person. For instance, to be a good prosecutor might not allow you to drink whiskey in your office, while to be a good advocate you might need to drink whiskey in your office. But that is just a silly example. But so it's a completely different investigation, and I think on the question earlier from the panel, to be a good admitted advocate does not mean you're automatically a fit and proper person to occupy the role. There are other considerations as well. Obviously, if you're not a fit and proper person to be an advocate, you cannot occupy the position. But if you are a fit and proper person, you could still not be a fit and proper person in terms of this inquiry, because there are different considerations that have been touched on in the debate, such as misconduct, such as suitability, etc. You might be fit and proper to be an advocate, but not be able to be a leader or manager of anything, and that simply wouldn't allow you to occupy your position. So when we say the fit and proper person test also has to be dealt with, we agree, in a robust manner. It can't be in a narrow, very stringent manner that would lead to the prosecutorial independence, which has got very many different flavors to it, being so affected that prosecutors become too scared to take any decision, to do anything. We get to some of the positions, like in some of the municipalities, where they rather just let the courts decide a matter than actually take a decision and thereby waste millions of rands worth of taxpayers' monies. they still have to have the confidence that if they take a decision in a bona fide manner, applying their minds, whether they're right or wrong, they will be backed and supported. They can't be looking over their shoulder the whole time to think, well, I'm going to end up like Advocate Mokgoro because someone disagreed with me and I'm going to be dragged off to an inquiry of this nature because there's this. It has to be a fairly robust, and we use the word gross. It has to be gross incompetence or grossly reckless in making the decision. Obviously, if it's male fide, it's male fide, or if it's corrupt, it's corrupt. Those two are gross on their own. But and I think Advocate Arns also defined it. It has to be something bad. It can't just be a difference of opinion. There has to be something substantial that makes you think, how can this person be allowed to be here? On that, we submitted in the case of Edmund Mokgoro, there's nothing of that nature, and we would ask the panel to make a recommendation that he is a fit and proper person to continue with his career. Thank you, ma'am.
Thank you, Mr. Rip. Any questions? Any further questions? We have your submissions detailed.
Yes.
Thank you for those, and thank you for your oral submission.
Thank you.
We have
Thank you,
no
ma'am.
further questions.
No, I don't have questions. I'm not going to speak again, ma'am.
You can forever hold your peace. Yeah. Thank you so much. Ms. Bauer, housekeeping?
I think we've more or less come to the end of housekeeping, other than that we would distribute written submissions made by the evidence leaders, and we'll make arrangements with our colleagues on that. And maybe one final thing is to thank the staff from the Secretariat on behalf of the evidence leaders for the support that they've given us in this process, and the people behind the cameras, the microphones. It's worked incredibly well with very little interruption, and they've been simply incredible in providing us with support and transcripts as and when required. And to my colleagues on the other side, it's been a most times relatively painless experience. Thank you.
Thank you so much for those encouraging words, Ms. Bauer. And from the panel, we truly appreciate your input. Okay, we have found these proceedings extremely helpful, and we thank you for your, with both sides, both the evidence leaders and the counsel. Your submissions will come a long way to assist us to unravel these issues and report as we should. We are very grateful for the cooperation that you have given us. Okay, and the staff, you have been incredible. It is amazing how within this very short space of time we have been able to achieve so much. We actually pulled it off, you know. We had expected that we will run into difficulties and have to ask for extension. We didn't want to do that, but we could see it coming. But we're grateful that we don't have to do that, or we didn't have to do that. We really appreciate the manner in which you cooperated in the way we conducted these proceedings. The media, you have been fantastic. You have allowed us to proceed with this inquiry without any particular disturbance. Okay, we appreciate that. There's nothing as offsetting as when you are busy with issues, procedures such as this, and you find people all over the place trying to get the best picture and the best sound bite that they need. You have been fantastic. Thank you so much. We appreciate your cooperation. The staff, the security, everybody. We have spent so much time doing so many other things, and we had thought that going through this process will make our lives difficult. We can now go back, or you can now go back, because we still have a long way to go. You can now go back and get busy with your other lives. Okay, and we wish you good luck. Which is that Mr. Dansman. Yeah, and the technicians, and particular Mr. Dansman, that's what we call him, because he had to conduct a dance right at the back whenever he wants to draw our attention to the need for a break. We are particularly indebted to all the witnesses who came forward and assisted us with evidence. In particular, the third-party witnesses who didn't have to come, but were willing to take the time to come forward and assist us. Is there anybody who I left out before I give Mr. Majavu an opportunity? Yeah. The researchers, thank you so much for, amongst others, doing what you were not paid to do. I didn't want to say pay. Doing what you didn't envisage you would do, okay? You came in and did what people who we thought we would get on board and couldn't get on board had to do. And you also provided us with the necessary research. That kind of attitude will take you far. Just keep it, okay? You don't have to be paid for everything that you do in life. That's a mantra that I have learned. And it takes you far. It takes you very far. Our spokesperson, thank you so much for your good English. Huh? She brags all the time that she writes good English. That is why she's our spokesperson. Thank you very much. Yeah. And thank you very much for your organizational skills. And we've had a couple or so of birthday parties. We've celebrated together. And it was lovely to see all of us as we're sitting here in this room, including the media, counsel, evidence leaders, the panel, everybody celebrating together, okay? Celebrating other people's lives together. Because you know that I'm very big on Ubuntu. We are here because of you. To our two, what did you call them, Mr. Masuku? You call them the stars. To Ms. Giba and Mr. Mkhwebi. Thank you so much for your willingness to subject yourself to this process and in a number of ways also assisting us in what we need to assist in our report that we will submit to the President. And Ms. Giba in particular made an impassioned plea to the panelists or to the panel to, amongst others, in their report, also report on what might need to be done, in our recommendations, what might need to be done in order to improve the situation of prosecutors in the NPA. And it was an impassioned plea. It was a heart-rendering one. It pulled at our heartstrings in a way, and we're very thankful for that statement. Okay. We just wish you strength. Everybody else, we wish you strength in the work that you do. Okay? If I've left anybody out, just raise your hand. Yeah, but thank you so much. Thank you to everybody. This was a grueling process, but it was worth doing it because we were doing it with you. Thank you. Master Majab.
Thank you, Judge. It's not every day that you get senior silks allowing an attorney to have, the final say, and for that I'm greatly humbled. On behalf of teams Giba and Mokgoro, I've been instructed to express our great appreciation to you as a panel because you thanked everybody else. And I've been told to tell you in uncertain terms that we have absolutely no qualms about the fairness and the propriety of this process. And we wish you strength and wisdom to do what you do best. And we say Nangomso. Thank you very much, Judge and fellow panelists, for putting up with us and giving us indulgences as and when same was required. And I thank you.
Thank you so much. We are humbled, truly humbled. Okay? Nasrin? Thanks for your leadership. Okay? Yes. Why do I feel that there's something I haven't said? I hope I've said it all. Thank you so much, guys. I think we've come to the end of our oral proceedings. Okay, yeah. And we're going to get busy with other work, and which is still part of the inquiry. And we're going to spend more sleepless nights. Okay, thank you very much. There was an idea that we take a group picture.
Oh, no.
Yes, there was an idea that came from somewhere there, that we take a group picture. Oh, it came from the communications person. Oh, sorry. I handed over your thunder to somebody else. Sorry about that. Okay, we will oblige.
So we are adjourning. Let's go over adjourn. Let's adjourn.
That's a journey.